I think this is Mr. Michael, who's currently in the Greenwood County Jail. And if I remember correctly, we had stipulated to failure to complete the drug and alcohol treatment. And that's where it ended.
And I show there's been an addendum filed May 31, violation of a protection order, and 3 pending cases in Greenwood County.
Well, Judge, I think we took that stipulation up, or that addendum up, on the 2nd as well.
Okay.
And I think there was no stipulation to any of those.
Okay. So we just need to do, has the court already taken up the admission by Mr. Michael?
Your Honor, I think I'm going back through my notes, and it looks like we did at least address that. I don't know that I don't have any notes specifically that we addressed the addendum. So it sounds like there's no stipulation to any of the information in the addendum. Is that correct, Jim? There's an allegation of a positive UA.
The allegation in the addendum is the charges in Greenwood County. And then the allegation of the positive UA, I can tell you there was no stipulation to any of those. We did take it up. I know my notes indicate we take it up, but there was no stipulation to any of those.
Okay.
I don't know that the allegation was necessarily that he had the 3 pending cases. I mean, that kind of is what it is, but I think the allegation is that he failed to inform his ISO.
Okay.
The fact that he had law enforcement contacts.
On the 2 violation of protective order cases, he never told me anything about those.
I think he's declined to stipulate to those.
All right.
Well, is he declining to stipulate that he failed to report it to court services, the probation office?
Well, I've slept since then. My understanding is that he did, but I think I'll need to consult briefly with Mr. Michael.
Okay, that's fine. We'll go ahead and put you in a breakout room, Jim, with Mr. Michael.
And Jim, maybe before you accept that, let me send you a little message here.
Okay. Okay, I'll run it by him.
All right.
Thank you, Chris. And announcements to the court, Jim, before going on the record.
And it sounds like he'd stipulate to basically everything other than the failing to obey laws. He's not going to stipulate he's in violation, but he can acknowledge that he didn't report his arrest and that he tested positive for the meth.
Okay, thank you, Jim. Rhonda, we'll go ahead and go on the record. Case is entitled State of Kansas versus Jacob William Michael, 21 CR 391. State of Kansas appears by Assistant Butler County Attorney Brett Sweeney. The defendant, Mr. Michael, appears in person and by court-appointed counsel Jim Watts. This matter does regularly come back before the court this date on the warrant show cause docket by Zoom, and announcements to the court. Mr. Watts.
Thank you, Your Honor. I've discussed the matter with my client. As Your Honor may remember, he had previously stipulated that he failed to complete the drug and alcohol treatment. On the addendum, he can, after discussion, stipulate that he did not contact his probation officer following his arrest on the matters in Greenwood County, and he would likewise stipulate that he indeed tested positive for methamphetamine while he was in Greenwood County Jail.
Thank you, Mr. Watts. Mr. Michael, the court has been advised by Mr. Watts that you do wish to admit to being in violation of the terms and conditions of your probation as set forth on the record by Mr. Watts. Is that correct?
Yes, sir.
You understand by making this admission, the court could very well revoke your probation and order you to serve the balance of your sentence previously imposed.
Yes, sir.
Have you had adequate and sufficient opportunity to consult with Mr. Watts prior to making your admission here today?
I have. Yeah.
Mr. Michael, the court does find that you are knowingly and voluntarily admitting to the probation violations, and the court does accept the same. Recommendations for disposition, Mr. Sweeney?
Yes, Your Honor. I think there's going to be an agreed upon disposition that the defendant would serve a 60-day jail sanction and then be placed back on probation. One caveat, and this is something Ms. Wheeler and I had talked about, I do think that he needs a bump up to community corrections probation. He's already had a 2-day probation imposed dip, so we don't need to worry about that. But this is now multiple violations. I just think he needs the more intensive or increased supervision that community corrections probation can provide. I think all of the probation conditions that he currently has are appropriate, but I think a bump up would be necessary. Would ask that he report to community corrections, should the court follow these recommendations, report to community corrections as soon as he's released from that sanction, or I don't know exactly what his Greenwood County obligations are, but whenever he's released. As it relates to any extensions on the probation, I think that Ms. Wheeler has already done an extension back in March of this year. This case has been going on for quite some time, but I think we're good as far as extensions. Those are the state's recommendations, Your Honor.
Thank you, Mr. Sweeney. And Mr. Watts?
Thank you, Your Honor. I may have misunderstood Mr. Sweeney. I know he indicated that he was going to be seeking a 60-day sanction. I don't know that I understood that to be that we'd agree to a 60-day sanction, but I understand that was going to be his recommendation. Judge, I think that a 30-day sanction is sufficient here, and I'd ask that it run concurrent with whatever jail time he is serving the Greenwood County Jail. We looked it up. He got arrested on this warrant in May 18th, it looks like, was the return of service. So sometime relatively soon prior to May 18th, that's when it got returned. So that's about the time he got arrested on this matter. He did bond out on it, but since that time, he's been in custody in the Greenwood County Jail. Since, frankly, I don't know what day he went into custody on the Greenwood County Jail. It looks like May 16th. Looking at the date of the testing in Greenwood County. So it looks like he's been in custody since May 16. We'd ask this time run concurrent with whatever Greenwood County time runs. I said I think 30 days would be sufficient. We would agree he has had a 2-day dip previously. This is his first time before the court, but he had done the dip and have no objection to moving this case to community corrections.
And anything further, Ms. Wheeler?
I believe the calculation for jail credit is a few days off. Mr. Michael had bonded out in this case and then proceeded to be arrested on violation of protective order cases, 2 of them, after he bonded out in this case, with the last one with the alleged date of offense as May 21. I believe that may be his actual date that he started in Greenwood County Jail to current. But Mr. Watts was correct in stating that he's been in custody on those cases in Greenwood County, not this case here for Butler County.
It was May 21st, so you're right.
So has he served 5 days so far of whatever sanction the court would impose?
No, Your Honor, he got arrested on this warrant, and then bonded out quickly thereafter.
Okay.
That's my
So
understanding as well, Your Honor, that he bonded out on this case and then went into custody in Greenwood County.
Okay, very well. Thank you, Ms. Wheeler. Thank you, Mr. Watts and Mr. Sweeney. Subsequently, the court does order that Mr. Michael is now on community corrections versus court services. The court does order he do 60 days in the county jail. This would be independent of any time he is serving in Greenwood County, either awaiting trial or serving sentence that's been imposed. So this time is independent and consecutive to his Greenwood County cases. And anything further?
No, Your Honor.
Mr. Sweeney
No, Your Honor.
and Mr. Watts
No, sir. Thank you.
and Ms. Wheeler?
Forgive me, I was trying to write notes. Did you say that he was reinstated for just the extension time? His extension time on this case is good until October. Let me find that. Apologies. October 28, or are we doing a 12-month extension with community corrections from today's date?
Court orders 12-month extension with community corrections from today's date.
Thank you, Your Honor.
Yes, sir. Thank you.
There being nothing further to come before the court, court is in recess.